2, 1, and we are live. Good morning, everybody. We are completely ecstatic this morning because we have two guests, Brad Banias and John from Proce Pro. John, can you pronounce your last name for me?
Moye.
Moye. Okay. John Moye from Proce Pro. So this live, this is something that I have been promised all the audience for a long time because they are very intrigued about filing a suit against the U.S. government. And there is a lot of marketing. There is a lot of media that is, going on about Proce Pro. And there's a lot of questions about this. So without further ado, Brad, can you please introduce yourself?
Yes. Good morning. My name is Brad Banias. I am the attorney at Banias Law, LLC. I'm based out of Charleston, South Carolina. And while I'm an immigration attorney, 99% of my practice is suing the federal government, USCIS, Department of State, ICE, when people's immigration benefits get delayed or denied, or the federal government comes up with some ridiculous new policy. Okay. And I write all the materials and am the attorney advisor for Proce Pro, which is my colleague, John.
John, can you introduce yourself?
Absolutely. Yeah. So hello, everyone. I'm John, one of the founders, of course, of Proce Pro. I am not a lawyer. And my professional background is really in a few different spheres. I was in the nonprofit world. I was in education and then technology. And I actually use all of those experiences to utilize the materials that Brad prepares to help people get results more quickly using the lawsuits that we provide, the lawsuit services we provide.
Well, thank you guys for your amazing job. I wanted to make sure that the audience understand that there is the availability for them to use subtitles. The conversation is in English, but YouTube allows that possibility. So please use that tool for you at home. So the first question that I have for you guys, how do you guys met? How this interaction came into place with Brad's expertise suing the federal government and John's expertise in the tech world that created Proce Pro? Tell me about it.
Yeah, so let me start. So my first real job as a lawyer was with the U.S. Department of Justice. I was an attorney. I lived in Washington, D.C., and my job was to go out and defend in federal court USCIS, Department of State, Department of Labor. And so I would go out and fight delay cases and denial cases on behalf of the government. One of the things I learned while I was there was the most difficult cases for a trial attorney like myself at the Department of Justice to handle were cases against pro se individuals, because there's so many ethical and legal landmines that I can walk into as an attorney dealing with a pro se individual. And so, taking that, a lot of the pro se cases would resolve because it was the easiest way to kind of not have to deal. That's right. Not have to communicate or deal with the pro se person. It's much easier as an attorney to work with another attorney on the other side. Fast forward 10 years, I'm in private practice. I started working with the U visa community back in 2018 when we were fighting for waiting list decisions. We fought for advanced parole, overseas parole, and BFD delays is what we've been really focused on for the last couple of years. And the government, I was filing cases. I filed my first one with 10 people. They settled it. 25 people. They settled it. 100 people. They settled it. And it got to the point where I said, why do we even really need an attorney to do this? Because obviously it's going to cost more to hire me. And the government was resolving these cases routinely. And the other part is for better or worse, I try to think strategy first. I want, and John and Proce Pro, we all want the U visa issues to be fixed, right? It is not reasonable to take 5 years to issue a BFD or a bona fide determination. That's absurd. And so strategizing, trying to figure out the best way to fix that, we figured a combination of suits with attorneys, And then an army of pro se lawsuits would get us closer to the end game of fixing the system for the U visa community. And that's where John and our other partner Andrew and I, I've known John since college, we started talking, and I'll let John kind of take it from there and talk about the growth and kind of how Pro Se Pro works.
Yeah, thanks, Brad. So I've had the benefit of watching Brad's career trajectory, and of course, we've been close that whole time, and so I've heard him talk about what's going on in the government. Similarly, I spent the early part of my career living overseas in Latin America, and frankly, I gained a great empathy for people living in a foreign land because I myself was a foreigner. And as Brad talked to me and our other partner Andrew about these incredibly absurd and legally unreasonable delays, the drive and the motivation to do something was significant. And so, certainly Brad is the legal strategy behind everything that we do. And Andrew and I kind of bring in the technology assistance of like, okay, how do we build systems and processes and tools that equip everyday people to go into these lawsuits with a degree of confidence and frankly, a high degree of success, where we know we wouldn't be doing this if the vast majority of individuals who work with us are getting their approvals and getting them very quickly. And so, talking to Brad, I'm like, we can help a lot of people. And just to reiterate his point, our hope is to change the system. It's that with the group suits that lawyers like Brad and others across the country do for the U visa delays, along with the thousands of individuals filing pro se cases, USCIS will be forced to say, we have to fix this broken process because we can no longer put up with these delay lawsuits because they're right. We're settling these because they're right. And we need to fix the process. And that's the ultimate goal here.
That is a wonderful. So that is just very, very wonderful. So for the audience to understand, Brad was working for the government. So it was in the other side, right? It was working for the government, trying to just fight the people that was filing the suits that we are talking about right now. So he knows and he has expertise. And John knows how to put together in a combo, with technology, how to sell that and how to advance that in Pro Se Pro. So that is a platform that is, based at the website, and that is a different company. So, Brad, you talk about settling. Do you want to explain what is settling mean?
Yeah. One of the reasons I think these delay cases, or what a lot of people call mandamus, are so successful is they're so easy for the government to resolve. All they have to do is make a decision. That's it. And so when we use the term settlement, that's what we mean, that the government agrees to make a BFD and issue your work authorization without a fight. And so that's it. We don't settle for anything less. The settlements are typically, we got your lawsuit, we agree to schedule your fingerprints and then make a decision within 60, 80, maybe 120 days, just depending. If you've been waiting 2 years, it seems like the settlement goes a little bit faster than if you've been waiting 4 months, which is a reasonable way for them to do it. But a settlement means you get your bona fide determination and your work authorization.
Perfect. And John, can you explain us, or Brad, jump in, what does that mean, Pro Se Pro? What does that mean, Pro Se, and why did you decide to Pro Se?
Sure. So I have to admit, I did not know this. I said before I was not a lawyer. I didn't know the term pro se, which is a legal term, which it comes from the Latin on one's own behalf. And it's used in the legal world to mean representing yourself without an attorney. And so pro se, we use that and put the pro as sort of like, a shortened version of professional. We're helping folks with our courses, with our playbooks, with our guides, and with our tools become pros, and empowering everyday individuals of all walks of life, of all backgrounds, to take control of their process and feel like, yeah, I'm a pro. I am a pro se pro. And so that's that's kind of the genesis of the name, and using that play on pro se.
That's wonderful. Yeah. So Prosa Pro, it is written as John has it after his name. Prosa Pro, and that's how you guys can find it in Google if you wanted to find it. Something super funny. One person from the audience wanted me to refer to Jose Pro. So I'm like, it's not Jose Pro, it is Prosa Pro. So make sure that you're spelling it correct. And that's why I wanted to include it. Why, pro se, because in the legal world, we have so many Latin words, and that's what they mean, without an attorney doing it by yourself. Mm-hmm. Perfect. So, Brad, can you explain to us what is the process of the Mandamus? What is actually happening, behind the scenes?
Yeah, great question. So once you have your suit ready to go, it's a very narrow lawsuit. We try to encourage you to put, enough information to get what you want, but nothing too much, because it's your private information. You don't want to tell the world everything. Once the case gets served, and that's a legal term, that is served on the U.S. Attorney's Office, where you live, or Vermont, depending on what's strategically better for you, the government gets 60 days to respond. And unfortunately, there's nothing we can do to speed that up in these types of cases, in the vast majority. So it's kind of a hurry up and wait. So let's say you filed and served your case January 1st. That means the government would have all of January and all of February, and then you'd probably hear back March 1st or 2nd. Typically, what happens if they're going to resolve the case around day 45, day 55, the government's attorney will reach out to you and propose a settlement, or say, hey, we need another 30 days. What are your thoughts? But because you filed a suit, they have to answer. This is not like calling the 800 number at CIS where they say they'll get back to you in 7,000 minutes, right? They have to answer, or else they're in trouble with the court. And because they have to answer, they have to decide, are we going to fight this case and spend time and resources fighting a case where we can make the decision in 10 minutes? Or are we just going to resolve it to make it go away? And what we've seen in a vast majority of our cases of Pro Se Pro customers is they offer a settlement. And that settlement gives the person guaranteed adjudication timelines. So they may not agree to issue it March 1st, but they may agree to do what you need done by June 1st, July 1st. And while, you don't want it to take 6 more months, it's guaranteed. And I can also say this, in my experience, if they agree that they're going to do it in 4 months, it's not uncommon to see it happen in 2 months or even 1 month, because they want to satisfy that. And so most of our customers, have sent in the complaint, worked out a settlement. The government files the settlement on the docket, and the case goes away, and they get their BFDs.
Perfect. So when you're talking about a federal court or a court, can you explain that? Because we understand the part of USCIS, right? That is the federal government as well. But can you explain what is the difference between USCIS and a federal court?
Yes, great question. So when we talk about court, we're not talking about immigration court. We're not talking about USCIS. We're talking about a separate part of the government, the judiciary branch. And, the USCIS and the immigration authorities are over here under the executive branch. And the judiciary, the federal judges, are there to keep the executive acting lawful, check them. And so you will be in front of a judge that's been appointed by a president and has a lifetime appointment. They don't work for USCIS. And chances are immigration is something that's very different for them on their docket. And they see, criminal cases, they see bankruptcies, they see, the types of cases you see in the news that involve millions and billions of dollars. And they also hear these types of cases. And so they bring a reasonable person's perspective to this case. It's not USCIS defending itself and saying everything they do is right. No. This is a normal person who lives a normal life outside of the immigration bubble, and they can look and go, why would it take you 5 years to do something that takes 15 minutes? You know, a funny story, this time last year, actually, I think it's exactly a year ago today, John and I were in court in Vermont in front of a federal judge, and we were arguing a BFD delay case. And he had a lot of questions about pro se pro, which we explained to him. And, you know, he thought if the government's going to settle it, he wanted them to work more closely with pro se pro. But one of the things during argument is the government got up and said, look, you know, U visas were never intended for travel, on and on and on. And the judge looked up and said, you know, you're telling me I wouldn't be able to go see my mom? You know, my mom's 85. And if I was on one of these folks, I couldn't go see her and be able to come back to my life. And again, he kind of left it at that, but that shows his real humanity, right? He could empathize with the U visa community. You know, you're not going to hear that from a USCIS adjudicator. You're not going to hear it from an immigration judge. And that's because these folks are independent outside of that bubble, and they don't care to upset the people in that bubble. And that's why federal court is a good and safe place to go.
That's really well put. In the immigration world, we call them real judges, right? Because the immigration court do not have this type of judges that they are so independent. And they are, as you pointed out, they are not afraid or upsetting one of the parts or trying to be biased with one of the parts. We commonly see that in immigration court.
And I just want to jump in, you know, maybe this was the elephant in the room, but during the first Trump administration, you know, there was a lot of tough things that he did to the immigrant community in the United States, non-citizens. But what we saw is because he was so loud and proud about it, we saw the judiciary get emboldened and push back a lot more than the judiciary did during the Biden administration, frankly. And so that's one silver lining I think we will see going forward, is that, you know, there's all this negative stuff that's going to happen. Don't get me wrong. But going to court is going to be a better position because these judges want to push back against an executive or a president that's loud and proud about going to the ends of their authority and just trying to hurt people. And so, again, not real thrilled about what's coming here in a couple weeks. Don't get me wrong. But the silver lining is going to court is going to be is still a safe place, and maybe even a better place than it has been the last couple of years.
Yeah, that's true. You know, when you get the perspective or you are close enough to a federal judge, it is completely a different world. It is a very respected community. It is not where attorneys can bluff about what they're saying in court. You have to have your arguments really structured and with authorities, the proper authorities. And it's not somewhere where you are going to be joking around in front of the judge. So, yes, I am for the federal courts. Because they tend to be more formal, as in the difference with immigration court, where sometimes I feel that it's a joke and litigating these cases. I wanted to ask you, Brad. So, if it's so simple to file these suits, what is so difficult to find attorneys that file these suits?
Yeah, good question. When you asked me to introduce myself, I kind of said, yes, I'm an immigration attorney, but I do something slightly different. And, I think a majority, when I teach immigration law at the law school here in my town, I tell everyone it's primarily a transactional process, meaning people come to you, you help fill out forms, you submit them to a federal agency, and you do what you need to do to get that approval. And when you're in that role as a petition attorney, you don't question the requirements. You satisfy them because you want to get your client a visa. You want to get them, adjustment of status, whatever it is. Well, just like what I do is very different than that. I don't do petitions. In fact, I've never filled out a U visa petition for an individual because what I focus on is, what are these rules? Are these rules lawful? And are these delays lawful? And so it's kind of two different rationales and thinking. One is not better than the other. They're just different. And I think, most immigration attorneys are in practices, and this isn't a bad thing. This is just a different thing, are set up to be transactional petition attorneys. And that's great. That's what most of immigration is. What I do is very different, and I focus on that and litigate. And the example I use that most people get is you might go to a CPA to do your taxes, right? Or go to H&R Block, and they can help and advise and get your taxes in. But when the IRS comes and takes you to court, you don't go hire H&R Block. You have to hire an attorney that goes to court. And that difference, right, is kind of the difference between litigation and petition work. And so they're just kind of two different specialties. And to be frank, again, I'm very honest with this. I did petitions for a while, and I don't do them anymore because I wasn't able to keep up with all the details you have to keep up with to do petitions. It's hard. Deophelia, you know that. And it's also a whole full-time job to keep up with what's going on in the litigation space. And so litigation's come into vogue in about the last 5 years, I think. And more attorneys are doing it. But for the most part, if an attorney doesn't typically do litigation, the cost is going to be higher because the attorney has to learn how to do it, take all the preliminary steps, and kind of, if you're doing this 1 time or 2 times a year, it's going to be a more engrossing project. Because we're so specialized, and Pro Se Pro only does this, we're able to kind of be very cost effective and efficient because this is all we do. Just like attorneys who fill out U visas, you're very efficient in that. And so I hope that explains it. Most immigration attorneys focus on petitions, and litigation's over here. And so, the handful of attorneys are out there who kind of do the same thing I do. There's only a handful, and most of them are associated with a petition firm, right? And so, if you're looking for litigation and you're looking for an attorney, I would urge you to ask them about their experience doing it, because there's a very big difference, not in the quality as well as the cost of someone like a Pro Se Pro who, again, has built this process to be as efficient as possible, or an attorney like me who does nothing but this, and a petition attorney who's going to go litigate. I hope that answers your question. Again, yes. One is not better than the other. They're just different jobs.
Yeah, and they complement each other.
Absolutely.
So, yes. So if I hear it correctly, and what I have told my audience, it is that there is an attorney that files the petition, the U visa in itself, that goes to USCIS. And if something is happening here, there could be another attorney that has different expertise that it will file the case in federal court, which is different bodies, different agencies completely. So we have different expertise. We are focused on something different. However, when I explain to them what is the challenges in finding a good a federal litigation attorney, it is that attorney will have to know a little bit about immigration, right? Not only that, they have to be licensed, where you have to file that suit, which is another layer of complicating the issue. And on top of that, there is cost prohibitive. So it is expensive, right? So there is some steps, and that is the difficulty and the challenges that we find for these suits to be available, and that's where Pro Se Pro comes into place. So I'm so happy. So now, taking that, so when somebody wants to take the route of filing a mandamus through Pro Se Pro, what do they have to have?
I'll take this one, Brad. It's pretty straightforward. I mean, it depends a little bit on the case type, but we've been talking mostly about U visa, so I'm going to keep it to the U visa requirements. And we try to get exactly to the line of what's the minimum required information without getting too much, because ultimately the lawsuit is referencing the U visa application that's already on file. So there's not a huge need to reference a lot of the details for what's already contained in the petition work that's already been done. So predominantly what we're looking for and what individuals need to have to be able to do a lawsuit are their receipt numbers. They actually don't even need copies of their receipts, but they need their I-918, I-918A if they have derivatives, and I-765 receipt numbers, along with the important dates. They go with both the receipt numbers as well as some of the dates of, for example, when the crime took place and, when they entered the U.S., things of that nature. Things that most people would know off the top of their head or would have very easy access to. Those are the types of things that people need. But ultimately, when people call us and they're like, what information do I need? We're like, you need your receipt numbers and your receipt dates. Other than that, you probably know everything else in your mind.
Okay. So when somebody already have that information, they can go to the website. What do they do after that?
Yeah. So I typically say, when I'm talking to somebody new, I'm like, we have essentially a 5-step process. Step 1 is you sign up on our website. Everything is pretty much done online. You sign up, you make a payment. And after you do that, step 2 is you fill out a questionnaire that gives us all the information we need. That's those receipt numbers, those dates that I mentioned. All of that is done within an app. We've got an app that kind of walks somebody through the whole process and acts as kind of an ongoing status update of kind of like the Domino's pizza tracker. Here's where you're at. Here's what you could expect. And this is where kind of the technology comes into play, where our tool acts as much as a course or a playbook, where we have videos and text-based guides that say, here's what you should be expecting. Here's what you should be doing. Here, maybe you need to wait for a couple of days. Maybe something's in the mail. If so, here's a tracking number. All of those things are kind of built into the app. But that step 2 is filling out the form. Step 3 comes to our team. Our team prints out all of the documents. We do a revision for typos. We do a kind of like receipt checker and make sure the I-765 is like an accurate receipt. Make sure, there's not any obvious typos. The address is coming up as a known address in the US. And once we've gone through the typo check, we print everything out and we mail it. We print an entire package that's got all of the documents, everything that's needed to file and register a complete lawsuit. And then step 4 is back to the customer who's filing the lawsuit. They're going to get that package in the mail. They're going to sign all the documents that are in the package and then send that to court. We go so far as to give them an envelope that's already addressed with the correct court. It's already got the stamp. It's already ready to go. We make it as easy as possible. Got a little checklist that we put in there that's like, here's what you do. Here's the process. And that package is sent to court along with a filing fee. Should note here, and always note this, the courts do charge a filing fee to register. It's a standard rate across the whole country for federal district courts of $405. That's added. And then step 5 is back on us. And this is where we take on a responsibility. We do as much as we can on behalf of the individual. We ensure a proper service of summons. And Brad mentioned this official part. This is arguably one of the most important parts of the entire lawsuit process. It's something that lawyers who do litigation they routinely outsource to a third party. And so we're not doing anything out of the ordinary for somebody who's pro se to outsource this as well. What that means is we're submitting the registered lawsuit to the defendants, in this case, USCIS and the Department of Justice and the U.S. Attorney's Office. We're notifying them through the official channels that this lawsuit has been registered, that they are being sued, and that they have 60 days to take action. And that's a really, really important, critical part because it starts that 60-day timer that Brad mentioned. Once that's been served to the U.S. Attorney, properly served, they must respond. And as Brad mentioned, I think he said 45 to 55. We looked back at an average of response times, and based on the ones that we know, our average is 43 days of when we see a response. And for our customers, that response, just to kind of reiterate what Brad said and build on it, we see one of two things typically. There's either that settlement offer that Brad said where the government makes a promise of, hey, we need a little extra time, but we promise within a certain time frame we're going to make a decision on your application. Or 2, what we see in the other half of the cases is a decision is simply made. And there's no settlement offer. There's no communication with the government. There's no anything. The summons is served and within a matter of weeks, BFDs and EADs are approved. So it's about 50-50 on which ones our customers see, but ultimately, we've got a pretty good process down now. We've done this with a couple of thousand individuals, and like I said, we've seen people from all different walks of life, of different languages. From Spanish, nuestro equipo habla español, we speak Spanish. We've got some Portuguese, we've got some Gujarati and some Hindi, and some other languages sprinkled in there as well. But people from all different walks of life who have gone through this process and not had any challenges or issues.
That's great, because one of my follow-up questions was like, okay, so do you have somebody else that can aid you if they don't speak English? Because all these documents have to be served and filed in English, correct? So, and you answered, yes, we have, or you have, in your team, people that can assist you to customers that only speak Spanish.
Yes, so we don't have a lot of resources outside of English and Spanish. We are continuously adding more and more resources that are natively done in Spanish. So we're on the cusp of launching a few new things over the next couple of months. But yes, we have our entire support team. We do have phone support. Everyone who's on the phones is fully bilingual in English and Spanish. Better than me. I know you've heard my gringo accent there,
great.
but yeah.
That's great. That was a good Spanish. So here, the website is www.prosepro.co.
.co, yes.
Okay, so I'm gonna put it in the chat, and it's just gonna go in all the social media channels. So everybody can just copy that website, and it can go directly to your website, so they can see what they're talking about. And I have gone there many times, so you can go on there and select which type of case or which type of action you are most interested in. Mm-hmm. And this delay on the U visa, basically, right? Good. So that is very good. So all the checklists that you send it to the clients when they just speak Spanish are also in Spanish? All the guides are also in Spanish?
Not at this time. There we have the video guides all have Spanish subtitles on YouTube, but right now, that's when I said we got a lot of stuff coming. Yes, we're basically gonna put people into one of two tracks and say, okay, you're either Spanish or English, and everything will be natively in Spanish for the Spanish track folks. But that's where our team is great. And if you look at our reviews on Google, that's the most common comment that we get is the team was super helpful. We're helping. There are a number of folks who really don't speak any English, only Spanish, and with the resources we've got as well as the team support, have had little to no issues getting their lawsuit filed.
That's great. Okay, so let's get to the really interesting questions, right? Like everybody is just waiting for these questions. So how long do I have to wait for me to engage Proser Pro or reach out to Proser Pro from the time that I have filed my U visa?
Yeah, so I'm going to tell you, and then I'm going to explain.
Okay.
We urge people to wait 90 days.
3 months.
3 months before you file a bona fide determination delay case. And you might say, well, the government says it takes 5 years to do that. And you're not wrong, but that's an absurd amount of time. You know, a court actually in Cincinnati, the United States Court of Appeals for the Sixth Circuit, said that processing times, I can't remember the exact quote, but it's something like, it's like comparing snails in a snail's race. And basically they said, the government can claim it takes 5 years, but that could be completely unreasonable. So the reason we say 90 days is I've done a ton of research. I've gone back and I looked at what Congress said when they passed the statute that created the law, that created the bona fide determination process. And they said it should take 60 days. And the way that it came out, essentially they determine whether your application is complete and they do a background check. Well, by the time they send a receipt, they've already determined your application is complete. okay, for the most part, right? They've done 80% of the work. Once you do your biometrics, regardless of what the government says, it takes them 48 hours to get the results back. 48 hours, 2 days. And so that's why we say 90 days. And we have seen people file routine. Now, don't get me wrong. If you've waited 2 years, is that a stronger case than if you've waited 91 days? Absolutely. Absolutely. Is it wise for you to wait maybe 6 months before you file because you want to get past that 90 day? That's a decision you have to make. But people ask us this question, what's your deadline? And we say 90 days. And we've seen hundreds of people, customers, get settlement offers when they file in the 91st, 95th, 96th day. And so for other lawsuits, our timelines are much longer. So for example, if you want a waiting list decision, right, we think you need to wait a year. And that's a little bit different of a process, a little bit different of an analysis. And all of this comes from kind of the years of litigation I've done in this space. And I will say, I want to brag on Pro Se Pro a little bit. Pro Se Pro has started doing Freedom of Information Act requests. And then when the government doesn't respond, suing them to get the information. So as of, I think, right around Thanksgiving, we actually got a spreadsheet that included the data for every single bona fide determination they've made. So 240,000 lines of data. And all it had was when it got filed and when they made a decision. And it's fascinating data because a couple of things become very apparent. One, there's no rhyme or reason to when they decide these things. You see on the same day, you will see applications decided that were filed 2-3 years apart, 4 years apart sometimes. So there is no first in, first out. You should have no expectation that because you filed before your friend, you're going to get a BFD faster. That's a problem for the government. The other thing I found fascinating is there are days where they decide 8,000 BFDs in a single day. And then the next day they decide 120. And what that tells me is they've got the resources to get this done and get it done in a reasonable amount of time. If you can put all hands on deck and do 8,000 in a day, if you did that for a month, we'd be done. This would be over. And I guess I tell you all of this because this research is built into the complaints you file. And it's the government's own data at this point that shows 90 days is what Congress wanted. Well, they wanted 60 days. We're giving a little bit more time. And they have no rhyme or reason to how they're doing this. So they can't say, well, you'll be done in 2 months. Well, the data doesn't show that. So that's a very long answer to a short question, Deophilia. But I wanted to explain why our opinion is so much more aggressive than a lot of attorneys would advise.
Okay. So let's say that, your approval rate is high, but in the worst case scenario, you don't succeed in the suit. Will a person, a U visa applicant, get any negative effect of losing the lawsuit?
Great question. So this is where that description we talked about before between a petition and litigation really comes into play. The merits, whether you're going to get a BFD waitlist decision or a U visa or not, are over here. And good or bad, the actual merits of your case, whether you're a victim of a qualifying crime, whether your harm was enough, whether your waiver can be approved, is totally, is pretty irrelevant to how long they take to make the decision, right? They're two totally different questions. Are you taking too long? Are you qualified? And so if you lose the case that says, are you taking too long? It has zero impact on whether you're qualified and whether you're eligible. And so, no, I have lost, as an attorney, lost motions to dismiss where the government or the court kicked our case out, and all of my folks still got decisions, and most of them get approvals. I actually just had that happen here in South Carolina with a 601A delay case. We lost the case, like people are losing them around the country, but everyone got their 601As approved. And so there's no, and I think this question naturally leads to, if I sue the government, aren't they going to get mad and kind of go after me or retaliate?
Or put me in immigration court. You know?
Right. Put me in a notice to appear, that sort of thing. So I'll give my short answer, then I'll let John chime in here, because this is a very a serious question, right? If my neighbor sued me, I would be angry, and I would put my smelly trash next to their front door, and I would do all sorts of petty things, right? Thankfully, the government is not as petty as I am. And first off, it's illegal for them to retaliate against someone, take negative action simply because they filed a lawsuit. A lawsuit is a constitutional right, whether you are documented or not. Okay. And so they can't simply say, you sued us, we're going to do something bad against you. The second part, and this is just incredibly practical, is these lawsuits, as we've talked about today, they are between you and primarily the Department of Justice. Well, the Department of Justice has no role in deciding your application. Instead, the Department of Justice attorney is going to talk to the attorney, the head attorney at USCIS. And that USCIS head attorney is going to talk to a manager. And that manager is going to talk to their manager. And that manager is going to go pick up a file, put it on someone's desk and say, hey, go ahead and make a decision on this. And so the person making the decision may not even know you sued. So even if they wanted to retaliate, even if they were, you know,
making things more complicated for you.
That's right. They don't even know that they should, in the most part. So I can tell you this. I've been doing now private litigation for almost 10 years. And then a few years before that in the government. I can honestly say I've never seen a true case of retaliation in the thousands of cases I've dealt with. That's easy for me to say, right? But that's my answer. John, what are your thoughts on that? Because I know you answer this question every day.
Yeah, I mean, I share a lot of the same stuff. I also just speak to, you know, you mentioned the humanity of the judge, the ultimate official, the adjudicator who's making the decision, that manager that gets the file at the very end is not some appointee who's politically motivated or motivated by anything other than they're doing their job.
And they don't want to get fired.
Right. And ultimately, as much as Brad might be petty if someone sued him, that person isn't feeling, oh my gosh, that I'm offended that someone would sue me, because it's not them that's getting sued. And like Brad said, they're not really feeling the effect. So I think on one hand, there's the humanity of it. It's one person who's processing a file, and they know if it would be very clear if a case was decided unfavorably, if the merits of the case were there. So, you know, Brad hasn't, we haven't seen it with our cases. And in fact, the other thing that I say is we have great data now because of how many cases we've seen. And we know from the annual data that's published on U visas that about 20% of U visas are denied every year. So you would expect maybe with lawsuits, that number would be roughly the same. That, okay, we see, you know, 1,000 or so lawsuits a year, are 20% of them getting denied? And the answer is no. And in fact, the number of denials we see from folks who do lawsuits with us is below 1%, at least of the ones that we're aware of. And so it's not even that it's close. It's so far off to say, oh, this is having an impact, a retaliatory impact, is completely debunked by the data that we see.
Yes. And I think that this misconception comes from culture, from Latin America, feeling that if you pursue your rights and if you are advancing your rights in a legal way, in a constitutional way, then the government, it is going to get mad to you and do something against you. But that is not, I have to say that that's cultural, and this doesn't happen in the US. So you want to say something else, Brad, to that?
Well, I was just going to say on that point, you know, when I was in the government, if one of my clients, being USCIS, would have called me up and said, you know what, they sued us, forget it. We're just going to deny. We're going to deny. I was trained to say, hold on. I need to get my supervisor. You need to get your supervisor, because what you're doing would be illegal conduct. And as a Department of Justice attorney, I'm not going to be involved in illegal conduct.
Because you can lose your license.
That's right. That's exactly right. You know, even as a government attorney, one case is not worth your license.
Exactly. So one of the things here they're asking, it is about if I haven't had my biometrics, the appointment for the fingerprints and the biometric information, can I still file the suit?
Absolutely. And Brad, you can chime in if I misspeak here, but the timing that Brad mentioned earlier, the 3 months, that 90 days, that's irrespective of biometrics. Doesn't matter if biometrics have been done or not. It's solely based on the date of the receipt date of that 9/18. The lawsuit, if biometrics have not been completed, the lawsuit will spur that to take place. And typically what we would see in a settlement is the government promises to do biometrics within a certain time frame and further promises to make a decision within a certain time frame of having the biometrics returned. So there's no concern for waiting on biometrics. Focus on the receipt date on that 9/18 application.
So wait, you're saying that if they haven't had biometrics, actually it is more convenient to file a suit because they will push the government to actually do something about it they're sitting on.
That's right.
Okay, good. So as Brad pointed out, we have a chaos with USCIS in the terms of, because the normal question that I have, it is when can I expect my bona fide determination, my EAD? And before we have the bona fide determination, which you were 2021, we more or less were able to say where immigration was in or what they were telling us. But now I feel that they're all over the place, that they are taking cases from whatever year, so which aligns with Brad was talking about. So here we have also that the principals have gotten the bona fide determination. They have gotten the EAD, the work authorization permit, but the derivatives are getting nothing. So the derivatives are just waiting, sometimes even a year, to get the bona fide determination. Can a derivative sue even though the principal has gotten the bona fide determination and EAD?
Yes. Short answer, yes. And that's become, to your point, a more common lawsuit that we've seen over the past 12 months. But yes, those are equally effective. The legal precedent is largely the same. I'll let Brad speak to that, but absolutely. The short answer, yes. If derivatives, we call it our derivatives only suit internally, we do quite a number of those.
Good.
And I'll just say those cases are even maybe one step stronger, frankly, because all of the hard work's been done on the principal's application, and these others should just fall like dominoes.
Should fall like dominoes.
Well, and again, this is the problem with, we all do this. We describe this process as being in a line, and that's just an incorrect metaphor, right? It's more like a pool that's deep, and they reach in sometimes on the top, sometimes on the bottom, sometimes on this side, sometimes on this side, and and then drop them and decide them. And there's no rhyme or reason to it. And it's so broken that extends to derivatives and their own principles.
Yes, because this process should be, first I'm going to review the principles. Once the principal qualify, then I'm going to go and explore and study the derivatives. And that should be the order. And I don't know where it happened that they are completely out of order. And it is creating a chaos for, internally, and for us attorneys that are trying to appease our clients and provide information that is coherent and sound intelligent, other than I don't know what is happening.
No, I think USCIS, especially in the U visa space, puts petition attorneys in a really tough spot, because when it's not predictable, you can't provide predictions. And, that's what everyone wants to ask about. And it's a disservice that USCIS is doing to its own customers. And that includes the petition attorneys. And, that's why I think, again, our overall goal is to fix it. is to get them to change it so that it can be predictable, so that the U visa can, serve the purposes for both law enforcement and for victims of crime that it's designed to serve.
Yeah. And I'm going to show you this comment that is saying, that's my case. So Christian, I'm so happy when we do these lives and somebody else is like one of the person from the audience. It is, oh my goodness, they're talking about like something that is happening in my life, so I can do something about it. So Christian, go to Process Pro or talk to an attorney and get the information required, and you can sue. The other question that I have here, and you mentioned it, Brad, it was about parole for the people that are outside of the United States. Can you talk more about that? I'm intrigued.
Yeah, so this is an exciting case that have been going very well in the pro se space, and that is this. We've been talking about BFDs, or bona fide determinations, all morning. But in the regulations, and before there was the bona fide determination process, there was this benefit called the waiting list. The waiting list is still there. And what the waiting list regulation says is, if you're given a waiting list decision, I think it says USCIS shall or will provide deferred action or parole. Well, for those of you in the United States, we focus on the deferred action part. We don't focus on, if you get a waiting list decision and you're outside of the country, you are entitled to parole. And when I say parole, I don't mean humanitarian parole, where it's, you have to show all these hardships. You are entitled to it as a member of the waiting list, period. And so what these lawsuits look like is they are different than the bona fide determination lawsuits. Typically, what we see is you have one person in the United States and their family outside of the United States, a very common scenario. And this person gets a BFD, and these, spouse and children, under the policies, someone who gets a BFD will never get a waiting list decision. And that deprives these folks of getting a waiting list decision and parole. And so what we do is we go in and we say, actually, this person's entitled to a waiting list decision, and they need it because their family is entitled to parole and they want to reunify their family. And USCIS multiple times has said in Congress, in reports, yes, we're required to do parole for people outside of the country, and they've never done it. And the benefit of these suits is you're not required to file a parole application. So I actually think they're probably less expensive than trying to get humanitarian parole. And the way they've worked is they decide whether you have a waiting list, whether you're qualified for a waiting list decision. If you're in the US, they send you a waiting list decision and say, great, here's deferred action. For those outside of the country, it says, great, you need to complete a DS-160 with your consulate, and the consulate will call you and set an appointment. And once it's at the State Department, the only complaint I've gotten is they move too fast. And you see people who, have to uproot their lives in 30 days. But then they travel to the US. Once they get to the US, they file for work authorization. And that application gives them deferred action and work authorization. And they can now be in the US as one family unit until they get an actual U visa, which other data we've gotten from the government, if you filed 2024, it looks to be at least a 17-year wait. So reunifying your family now, a year into your wait, is incredibly important, regardless of what's going to come next. And so those suits, the government, they've been working very well. They did fight me in some of my cases where I had clients, but we resolved them, and we now have kind of a standard settlement, just like we do with the BFD. Those take a little bit longer because there's two agencies involved. A waiting list decision is more substantial than a bona fide determination, right? But it's a very effective case, and it really brings families together. We also have one for who everyone's outside of the country, just so you know. It's slightly different. You have to have waited a little bit longer, but not too long. And I love nothing more than getting an email that says, I got to see my wife and child today for the first time in 3 years. And that reminds me why we do this, because the U visa community has already, by definition, suffered enough. And whatever we can do, pro se pro, Deophilia, Banias Law, to limit the suffering and to bring your family together, we want to do it.
Exactly. Here is a question that I was going to ask you. Marta says, can I apply for parole with Proce Pro? I have been waiting outside for the U visa for more than 6 years outside. So she's talking about applying for waiting list parole when she's the principal. Can she do that?
Yes, absolutely. When someone's been waiting for that long, I typically check their date just to make sure that we're not going to run up against the actual U visa potentially, because I do believe, whereas the BFD and the waiting list decisions are not first in, first out, they're a little bit better with the actual U visa. And so we have a high degree of predictability when the actual U visa might be awarded. So for 6 years, so that's 2018. Yeah, she's probably got a few more years. So she would probably want to be looking at the parole. And that's someone that we right now we say 15 months of being of application time for the 918. So 6 years is well beyond that.
Yes. So basically here, what John is saying, it is that they don't want it to file a case where the U visa is coming. One of the 10,000 is coming. The approval is coming up. So here right now, what I have seen is the approvals are coming up from 2016, is slightly getting into 2017. Mm-hmm. So if she filed 2018, there's going to be quite some years for her to be able to immigrate into the United States. So it could be good for her.
Right.
So I will say from the data we've got, we think that they will reach, for actual U visas, they will get to the end of March 2017 during this fiscal year. Then next fiscal year, so starting in October of 2025 through the following one, we think they will get to November of 2017. And that's, again, we have a really cool tool on prosepro.co where you can type in your date and your filing date, and it'll give you a prediction based on this data of when you'll get your actual U visa.
Yeah. And there's a little bit more or less what I have in my mind. So I put 3 fiscal years in 1 calendar year. Around.
I think that's right. I think that's right. Our model just takes into account kind of, when we look at the data, like the denial rates, they skip people still. They do a better job, but they still skip about 13% of people when they're doing the actual U visas. And it is what it is. But
yeah,
I guess we see our goal as that's going to be a long wait. Even if it's another 2 years, that's a long wait. So if we can put you in a safe position, especially with the new administration coming in, so you can wait in safety for at least the next 4 years, that's our priority.
Mm-hmm.
Perfect. Yeah. One of the last questions, because we are approaching the hour, it is, if I file a lawsuit, will my attorney of record be my attorney of record for the U visa? Yes. Or would I lose that representation?
Thank you so much for asking that question, whomever did, because this is one of the first things that I tell folks. I said at the beginning of this video, I'm not a lawyer, and Brad is not representing anybody who works with Proce Pro. And what that means is your lawyer who's done your application work will continue being your lawyer, your trusted advisor, and the person who's going to get all of the communications about your application. You're going to be getting direct communications about your lawsuit, but all of the application stuff, if there was a request for evidence, if there was, the actual approval bona fide determination, the I-765 approval, the EAD, those are going to be going to your attorney. And so they're going to be the ones who are going to be learning about your approvals first. And they're going to continue advising you on things that need to happen as you go through your U visa process. So I using the analogy, a different analogy than Brad, I think in the medical profession of the way I explain it to folks is, your original attorney is kind of like your general practitioner, your general doctor. They're going to guide you through all the ins and outs. We're a specialty doctor. We're here helping you with this specific delay to help get things moving. But as you go through the rest of the process, your original attorney is still your advisor.
Perfect. Thank you very much for that answer. So when we are talking about deferred action, what does that deferred action mean, Brad?
It means the government's not going to physically remove you from the country. It's a promise to not deport you. which again is going to be more and more important as the Trump administration takes hold.
Which leads me to the next question. Do you think that it's advisable now more than ever that folks, the audience, file the mandamus if they can't get a deferred action because of what is coming?
I think so. We don't know what's going to happen with the U visa program under the Trump administration. I've been peppering the government attorneys who I talk with every day. They don't know, right? Because the new people aren't in place yet. They're not doing their demands yet. But if we look at DACA as an example, right? What we saw in DACA was, even though they eliminated the program, everyone who had an application in place, or everyone who had a deferred action in place, they kept it. And so getting your suit in soon before they take action is likely going to be better than waiting. And if they end the bona fide determination program, which they are able to do, there's going to be a fight over it, of course, but we want to be in a position to have that fight and ready to go. And you'll be in that position as well. And again, we've also built some things into the lawsuits just in case, right? To protect you if the BFD goes away, you're still making a claim for a waiting list decision, right? And so, when I look at the next 4 years, the only thing that we can do right now is be prepared. And that's what Pro Se Pro has done a very good job of preparing, to additional districts, to new complaints that take into account the data we've gotten, as well as backup causes of action. So that hopefully we can continue to get the U visa community the results they deserve. And it's still a shame you should have to bring a lawsuit to do this, to be frank. The government should be treating you like kings and queens. Instead, it doesn't. And this is our way to push back.
Great. That's great work. So just for me to understand and for the public to understand, Pro Se Pro is for-profit agency, is a company, which John, it is one of the person that create that company with the help of the legal help of Brad, which is the attorney here, right?
That's right.
So, and you guys work together if something happens in one of the cases that Pro Se Pro, for the clients when they file it. So when you're doing Pro Se Pro, yes, you are by yourself, but all the documents were created by an attorney. You want to expand on that so the clients can have a little bit more confidence, and that will be my last question to wrap up. If you have further comments, please do so. But so they can feel more confident about what they are filling out and filing on their behalf.
Yeah. I'm going to say one thing, and I'm going to toss it all over to Brad. One of the things that we do have is a really robust community of all of the folks who have gone before. We're crowdsourcing knowledge because some things do change. The way the government reacts, the way the courts react, evolve a little bit. And so as folks see differences or as new things come up, folks in our community are sharing their experiences. We have this private kind of community for everyone who's going through one of our lawsuits, and people ask questions and get a lot of answers. We're not permitted to give legal advice at Pro Se Pro. We're allowed to help people follow a process. But so we stay away from giving legal advice, but there's a lot of vibrant, robust assistance from individuals in our community of just people helping others. So that's one of the great things that we don't really talk about a ton in our services that emerged as this really great thing. We're all in this together. We're all fighting for change, and every single approval that comes through is one more person who's got that protected status, who's here. But above and beyond that, I'll let Brad speak to the evolution of legal strategy and how we ensure that folks are protected as best that we can.
Yeah, and I'll just kind of give my concluding remarks also. John and I talk every day. If I need to tweak a complaint, I do. It's not, I cannot do something in your case for you because I don't represent you, but I can provide templates, I can provide responses, and I do. And we work on that regularly. But the exciting part about this to me is that it's incredibly easy for you to do this process, and then you're in control. If you want to call the government attorney 1 week after you filed it, we're going to give you the number. If you want to email them once a week, every Friday, you can do it. And this isn't an 800 number that's going to put you on hold for hours. This is going to be a real person who has real control over your case. And, we urge people to act reasonable. Don't call every day. But this is your case. This is your case. And this is a way that you can take control over your journey. And that's why I just love it, because, it humanizes these cases for these government attorneys because they're talking to the actual person. It shows how difficult it's going to be to defend this case. And it gives you the ability to do it on your own without having to reach out to Deophilia or even Pro Se Pro. And then once it succeeds, share your experiences with similarly situated people. And we see people who have been granted it a year ago still answering questions for people on Facebook, still chiming in because they want you to have the same results they did, because it's an empowering experience in the end. And I feel like that's the best thing we can provide you, show you that you can do it and do it well.
That's a great wrap up, guys. Just one more thing here, because Carolina is confused and she doesn't know now if she should have the biometrics. You don't have to have the biometrics to file a suit. End of the story. Okay?
You do not need biometrics.
So I wanted to congratulate you guys. And one disclaimer, Valencia Diaz doesn't get anything from Pro Se Pro, and it's not related to Pro Se Pro either. I am passionate about spreading information, as well as Brad and John here for the U visa applicants, but I'm not by any means related. We are just colleagues, and just reach out. Please help me to spread the word. Please help me to just help these applicants that they're desperate, and they agreed to do so in this live, which I'm very grateful. I want to acknowledge you guys for the work that you are doing, for the passion that you have demonstrated to help the immigrant community. And I can tell you that it makes me very, very happy. And I'm so grateful, because it's one thing to see an immigrant helping another immigrant because they know what they're going through. But seeing strangers to immigrants helping immigrants is a different thing. So this is something that strangers do care about, wound or suffering that they are not enduring. So thank you very much. And I want to acknowledge for that, and for your passion, for your knowledge, and for your hard work every day. Thank you for being with us today.
Thank you, Deophilia.
Thank you, Deophilia.
Well, we will chat soon. Okay. Bye-bye.